There isn't an offence of graffiti per se. Chances are you'd be arrested for criminal damage under the Criminal Damage Act 1971 if the damage is not more than £5,000, unless it's caused by fire. It's treated as if it's triable only in the magistrates' courts, what we lawyers call summary only. That basically means that you cannot elect a Crown Court trial if the damage is less than £5,000, and a lay bench of magistrates or a district judge will hear the case in the magistrates' court. You tend to look at people who are, I don't know, bombing or spraying tags on walls. It's generally low-level damage. I'm not talking about high-end trains here. I'm talking about sort of low-level petty damage. That would tend to be kept in the magistrates' court and be summary only. The sentences that you can get for criminal damage, if it's a low value, it tends to be a maximum of 3 months imprisonment and a fine. That would be the highest sentence that you could get. Obviously, the higher the value, the more that can be affected, and the greater the sentence that you can get for it. Trains would obviously be a higher value than your average piece of graffiti. It takes an awful lot more resources to scrub the graffiti off trains, and that's taken into account when the case as a whole is looked at. So yeah, that would be a much higher value. The police can detain you in the police station for up to 24 hours initially. During that time, they're allowed to keep you for the 24 hours in order to question you and make further investigations into the alleged offences. After 24 hours, a further extension can be authorised by a custody sergeant. This can go on for a maximum of 72 hours. They can't hold you longer than 72 hours unless they go to a magistrate's court and they have a warrant to actually extend the amount of time that they're allowed to hold you for. In general, it tends to be 24 hours at the very longest. Interviews don't tend to happen immediately by any means. If it's your first time there, there'll obviously be no record of you on the system, and those records need to be created. You have your photograph taken, your fingerprints taken, and so on and so forth. If you've been there before, the same thing happens. They'll again take your photograph and take your fingerprints and run you through the system to try and track down any previous convictions that you might have that they might want to know about because they might think are relevant. What generally happens is you will be offered a solicitor. There's a common myth that duty solicitors tend to be the worst types of solicitors going, hence their duty in the police station. That's simply not true. There are an awful lot of really good solicitors who have what are called duty slots. The police may well say to you, look, we're ready to proceed to interview you now. If you want to have a solicitor, it will take an awful lot of time to get one down here, and you could be looking at sitting in the cell for a number of hours. If you imagine that you're probably not very impressed at having been arrested in the first place, you really don't want to be there. You're quite keen to get it over and done with as quickly as possible. All of that may make you more inclined when you hear that it could take several hours to get a solicitor down to the station to give you advice. It may make you more inclined to waive your right to a solicitor and be interviewed without one. I'd strongly recommend against that. People have no idea how much trouble they manage to talk themselves into because they haven't got a solicitor there. You don't know the law, you don't know the ins and outs of what you're saying, and you don't know how your words may be manipulated if the case gets to court. Never be interviewed without a solicitor present. It's simply not worth the trouble that you may well talk yourself into. They're there for a reason. You do have the right to legal advice. That legal advice could take the form of speaking to a solicitor on the telephone prior to going into an interview. You might speak to a solicitor on the phone, they'll know the brief facts of your case, and you may well then decide that you want to be interviewed without. But again, that's not something I'd recommend under any circumstances. You simply don't know the trouble that you're going to talk yourself into. It also depends on other things. Before you're interviewed by the police, if you do have a solicitor present, the police will make initial disclosure to your solicitor. That's basically outlining the allegations against you and so on and so forth. If you're being interviewed without a solicitor present, you're not going to know about things like initial disclosure. You're not going to know what the police are bound to disclose to you before going into interview. And if you don't know what it is that you're looking for, chances are you won't miss it if it's not there. The whole purpose of an interview is it's your first opportunity to give your version of events and effectively explain the circumstance from your point of view. But it works like this. Often you may be better not saying anything purely because you don't know effectively, for want of a better phrase, what cards the police are holding and what information they've got. What tends to happen is this, that you'll be warned that if you choose to exercise your right not to comment in an interview, and I stress that it is your right not to say anything, if you exercise that right, then you'll be warned about what's known as an adverse inference. If the case does come to court and you haven't commented at interview, for example, you haven't used that very first opportunity to put forward your version of events and explain things from your perspective, then the jury or the magistrates will be told about the adverse inference, which is they are allowed to draw an adverse inference from the fact that you didn't take the opportunity to explain things in the first place. What tends to happen is this: a lot of solicitors will advise their clients not to comment in an interview, and that's simply because you don't know the full picture at that stage, and as I said earlier, you simply don't know what information the police may or may not have. If initial disclosure hasn't been made fully enough, or for whatever reason your solicitor is not happy with you giving a full comment in an interview, then they may well advise you not to comment in that interview. That has one way of going around the adverse inference. If your solicitor advises you not to comment, then it's highly unlikely that you're going to go against that advice. You don't go to the doctor and then not take the medicine that he prescribes for you. It's the same principle. The fact that the police and the courts talk about an adverse inference, if your legal advisor has advised you not to comment, then that can simply be put before the court that it was on legal advice that you didn't comment, and that should go some way to counteracting the adverse inference that could be drawn from you not doing so. It's not simply the comments in an interview that can be adduced. You may come out with something in the police station, and the police officer may well ask you may well write it down in his notebook and ask you to sign his notebook that the words that he's written down that you came out with are true. That would be called what's known as a significant statement. When the police arrest you, any comments you make on arrest, any comments you make on caution, everything like that will be noted down in the officer's IRB, their incident report book, and all of that may well be able to be adduced at trial. So it's not simply what you say during interviews that can be given as evidence in this matter. It's all comments that you make pretty much from the moment that you have any interaction with the police. There may be some legal argument to exclude some of the things you may have said, but you can't count on that. You've got to be very careful what you say from the moment the police arrest you. And indeed any comments you make prior to arrest. They're not limited as to what areas of the house they can raid. They can raid your whole house. And I believe, to the best of my knowledge, that also extends to your garden. They're certainly not limited. There's no time limit as to how long the raid can take place for. It's simply they're looking until they're finished looking. The best advice I could give anyone in that scenario is just to keep your head down and not create any trouble. There are offences that you can commit without even really realising you're committing the offences, such as obstructing a police officer. You can be found guilty of obstructing a police officer if you make it more difficult for them to carry out their job. It's a very wide definition. Simply not answering questions can't be considered obstructing per se, but it's a very wide offence. And you get a situation where members of your family may well be upset if their house is being raided, and they could come out with things that would potentially make them guilty of committing that offence. Cooperate as much as you feel able to. And just keep your head down and don't make life unbearable for the police officers. If there's a match on the DNA database, the chances of it not being you are pretty much slim to none. Handwriting's far more variable. Handwriting experts will be called in. Plus, it tends to be my experience that a lot of graffiti artists, the tags that they're throwing up, they're nothing like their everyday handwriting. The two are quite distinct. It's quite possible that you'll be asked to give a handwriting sample before you go into interview. Depending on the fact of your case, I'd really seek to rely on your solicitor's advice as to whether or not to do that. That's why I keep stressing that it's really important to be interviewed with a solicitor present and not to try and do it on your own. You don't know the pitfalls of agreeing to it. You don't know the pitfalls of refusing to do it. That's why your solicitor is imperative in interviews for offences such as this. As far as answering questions about other people is concerned, 9 times out of 10 these are going to be your friends, and these are going to be people who you see on a daily basis and you spent quite a lot of your time with. I would always exercise care when answering questions about someone else. For example, you don't know if they've gone completely no comment in interview, and you could be dropping them in it entirely. It may well be a good idea to answer the questions you want to answer about yourself and simply leave out reference to anyone else at that stage. I don't know, it really does depend on the individual facts of the case. The police effectively pull together the investigation and hand it over to the CPS, the Crown Prosecution Service, and they will then prosecute the matter at court. But the police have no say when it comes to sentences or sentencing guidelines. Absolutely not. Obviously, if you cooperate with the police, then the courts will take that into account, and they may well be slightly more lenient on you for your cooperation. But at the end of the day, the police simply can't guarantee you a lesser sentence for it. No.